Before we begin, a quick and important disclaimer. The following content is provided strictly for educational and entertainment purposes. It does not constitute legal, financial, or psychological advice. Divorce and family law are complex fields governed by varying state statutes. Therefore, viewers should conduct their own due diligence and consult with a licensed attorney or qualified professional regarding their specific legal situation. Imagine a world where the end of a marriage didn't mean a 3-year scorched earth campaign in a sterile courtroom. For decades, the American public has been conditioned to believe that divorce is a zero-sum game, a gladiatorial arena where the only winners are the attorneys billing $400 an hour. We have been fed a diet of cinematic shouting matches and high-stakes litigation, leading to a pervasive social stigma that if you aren't fighting to the death, you aren't doing it right. But a silent revolution is currently sweeping across the United States. Recent historical trends suggest that the era of the adversarial divorce is being dismantled. We are witnessing the sharp decline of the stigma surrounding divorce mediation, a shift so profound it is fundamentally changing the way American families dissolve and rebuild. Today, we are pulling back the curtain on why the old-school court battle is becoming a relic of the past, and how mediation evolved from a hippie alternative into the gold standard for the modern high-functioning exit strategy. For the modern U.S. audience, this transformation solves a critical high-stakes problem: the preservation of both capital and sanity. In an era of rising inflation and increasing awareness of childhood developmental trauma, the traditional litigation model is no longer just socially frowned upon. It is often viewed as an inefficient use of family resources. By the end of this deep dive, you will understand the systemic shifts that moved mediation from the fringes of the legal world to the center of the American domestic experience. To understand the decline of the stigma, we first have to examine the sheer weight of the history we are moving away from. For the better part of the 20th century, the legal framework in most U.S. states was built on the concept of fault. To get a divorce, you had to prove a moral failing. This inherently set the stage for conflict. When no-fault divorce laws began to sweep the nation in the 1970s, starting with California, the legal necessity for conflict technically vanished, but the cultural momentum did not. The stigma remained. If you chose mediation, you were seen as weak, or perhaps you were being taken to the cleaners by a more aggressive spouse. Case studies from the 1980s and 90s show that mediation was often relegated to low-asset cases or viewed as a desperate attempt by alternative types to avoid the rigors of the law. However, the data began to tell a different story. Research into potential outcomes for families revealed that children whose parents utilized mediation showed significantly lower levels of cortisol and fewer behavioral disruptions compared to those whose parents endured multi-year litigation. As this data trickled into the mainstream through the 2000s, the weakness stigma began to pivot. It started to look like intelligence. Consider the financial mechanics that have fueled this shift. In a traditional litigated divorce in a major U.S. metro area, it is not uncommon for each party to provide a retainer of $5,000 to $15,000 just to start the process. Between discovery, depositions, and trial preparation, the family's net worth can be eroded by 30 to 50% before a judge even hears the opening statement. Mediation, by contrast, operates on a model of cooperation that minimizes these procedural hurdles. As the U.S. middle class faced mounting economic pressures over the last 2 decades, the social stigma of not fighting was rapidly replaced by the social stigma of wasting the college fund. Furthermore, we must look at the role of the American Bar Association and the evolution of the legal profession itself. There was a time when many attorneys viewed mediators as a threat to their bottom line. Today, however, many of the most prestigious law firms in the country have added mediation wings. This institutional validation has been a massive catalyst in removing the fringe label. When the same high-powered firms that used to champion aggressive litigation started recommending mediation for high-net-worth clients, the public perception shifted. It became a luxury of the discreet and the sophisticated. We see this reflected in the way divorce is narrated in modern American media. We have moved from the era of Kramer versus Kramer, defined by heartbreak and courtroom drama, to the era of conscious uncoupling. While that specific phrase was initially met with some derision, the underlying principle, that a marriage can end without a total collapse of the social fabric, has taken root. This cultural shift is supported by the accessibility of information. In the past, a divorcing spouse's only source of information was their lawyer, who had a financial incentive to keep the conflict alive. Today, a quick search provides potential outcomes and success stories from thousands of individuals who utilize mediation to keep their private lives private. Privacy is perhaps the most undervalued driver of the stigma's decline. In our digital age, the fact that a courtroom is a public forum has become a terrifying prospect for many. Every filing, every allegation, and every financial disclosure in a litigated divorce can become a matter of public record. For professionals, business owners, and those in sensitive industries, the mediation room offers a black box environment. What happens in mediation stays in mediation. This shift toward prioritizing privacy has turned mediation into a status symbol of sorts. A way for the smart, set to handle their business without the neighbors or the internet knowing the gritty details. The step-by-step evolution of this process is also linked to the changing nature of the American father's role in the household. In the mid-20th century, custody was often a foregone conclusion, leaving little to mediate other than assets. As the U.S. moved toward a more equitable distribution of parenting time, and the tender years doctrine was replaced by the best interests of the child standard, the complexity of scheduling and co-parenting skyrocketed. Litigation is a blunt instrument. It is terrible at carving out the nuances of a modern 50-50 parenting plan. Mediation, however, is a scalpel. It allows parents to build bespoke schedules that account for soccer practices, work travel, and holiday traditions in a way a judge, who has 15 minutes to look at your file, never could. The decline of the stigma is also a story of professionalization. In the early days, a mediator might have been a well-meaning social worker or a retired teacher with a weekend of training. Today, the field is dominated by dual-qualified professionals, attorneys who are also trained in conflict resolution, and mental health professionals with deep understandings of family systems. This increase in the quality of the product has made it easier for the American public to trust the process. When you walk into a mediation suite today, you aren't walking into a basement office. You are walking into a high-stakes negotiation room, equipped with the latest in financial software and psychological strategy. We are also seeing a generational handoff. Millennials and Gen Z, who are now entering the years where divorce statistics become relevant, grew up as the children of the divorce era of the 80s and 90s. They saw the damage of the courtroom battles firsthand. They watched their parents' savings disappear and their childhoods become pawns in a legal game. As a result, this demographic has an inherent visceral allergy to the adversarial model. They are seeking out mediation not because it's the easy way out. Mediation is actually incredibly hard work, but because they view it as the only moral way out. As we move forward in this documentary, we will break down the specific mechanics of how this process works, the data points that prove its efficacy, and the psychological hurdles that still remain. The stigma is dying, but it isn't dead yet. To fully understand why the U.S. is leading this global shift, we have to look at the intersection of law, money, and the changing American heart. This is the new frontier of the American family. To truly grasp why the stigma is evaporating in 2026, we must look at the cold, hard numbers of the American courtroom crisis. Imagine a middle-class couple in Columbus, Ohio. Let's call them David and Sarah. They have 2 children, a suburban mortgage, and a combined retirement portfolio. Under the old paradigm, David and Sarah would each hire a high-powered litigator. In the current economic climate, those attorneys likely require an initial retainer of $7,000 each. By the time they reach the discovery phase, where every bank statement and text message is scrutinized, they have spent $20,000 of their children's future. Now, consider the alternative that is becoming the new American standard. David and Sarah walk into a mediation suite. They share one neutral professional. The total cost for the entire process might hover around $5,000. The math is not just a preference. For most American families in 2026, it is a survival strategy. This massive disparity in cost is the primary engine driving the stigma out of existence. When something is this much more efficient, the social pressure to fight begins to look like a lack of financial literacy. Historical trends over the last decade show that the average litigated divorce in the United States takes between 18 and 36 months to finalize. In a world that moves at the speed of the internet, 3 years of legal limbo is an eternity. Mediation, by contrast, often concludes within 90 days. This time efficiency has created a new social currency. In 2026, being stuck in a long, drawn-out legal battle is no longer seen as a sign of standing your ground. It is seen as being trapped in an outdated system. We are seeing a shift where the ability to navigate a civil, Mediated exit is viewed as a hallmark of high emotional intelligence and professional competence. Let's dive deeper into the psychological mechanics of the adversarial system that mediation successfully bypasses. In a courtroom, the legal structure necessitates a petitioner and a respondent. It is built on the language of versus. This binary creates a physiological response in the parties involved. When David and Sarah are forced into this structure, their brains enter a state of chronic fight or flight. Cortisol levels spike, and their ability to engage in complex problem-solving, which is exactly what you need when dividing a life, is neurologically impaired. Case studies from family psychology journals indicate that individuals in high-conflict litigation experience rates of post-traumatic stress similar to those found in high-risk occupations. Mediation functions as a de-escalation chamber. By removing the threat of a judge's arbitrary ruling, it allows the parties to remain in their prefrontal cortex, the part of the brain responsible for logic and long-term planning. The step-by-step breakdown of a modern mediation session reveals why it is so effective at dismantling the old stigmas. It begins with the orientation, where the mediator establishes the ground rules of mutual respect. Unlike a courtroom where a lawyer's job is to silence the opposing party, a mediator's job is to ensure both voices are heard with equal weight. In 2026, many U.S. mediators are utilizing advanced digital platforms to model financial scenarios in real time. Imagine David and Sarah sitting in a room while the mediator adjusts a digital slider on a screen, showing exactly how their cash flow will look in 5 years if they sell the house versus if one person buys the other out. This transparency eliminates the fear of the unknown, which is the fuel that keeps the fire of litigation burning. When you see the data laid out in front of you, the urge to scream at your former partner is often replaced by a shared need to balance the spreadsheet. Furthermore, the American legal landscape has undergone a quiet but radical shift in how it views the role of the judge. In many jurisdictions across the United States today, judges are actively pushing families toward mediation before they will even grant a hearing date. This is not just because the courts are backlogged, though they are, but because the legal community has reached a consensus. A judge, no matter how wise, is a stranger who will spend perhaps an hour total thinking about your family's specific needs. Mediation empowers the people who actually know the children's names and the family's rhythms to make the decisions. This empowerment is a total reversal of the old stigma that mediation was for people who couldn't handle the truth. In 2026, the truth is that no one is better equipped to manage your life than you are. We must also consider the role of technology in this transition. The rise of ODR, or online dispute resolution, has democratized mediation. For a couple in a rural area or a situation where distance makes in-person meetings difficult, video conferencing mediation has become a seamless experience. This has stripped away the physical intimidation of the courthouse. There are no metal detectors, no armed bailiffs, and no crowded hallways filled with people having the worst day of their lives. Instead, mediation can happen from the safety of one's own home. This shift in environment has a profound effect on the potential outcomes of the negotiation. Comfort leads to compromise. But what about the outliers? What about the cases involving significant power imbalances or complex financial holdings? This is where the deep dive gets interesting. In 2026, we are seeing the rise of the specialized mediator. There are now mediators who focus exclusively on tech entrepreneurs, on military families, or on families with special needs children. This level of specialization has addressed the old criticism that mediation was a one-size-fits-all solution. By providing experts who understand the specific nuances of a client's life, the mediation industry has effectively countered the argument that you need a shark-like litigator to protect your interests. The social impact of this decline in stigma cannot be overstated. We are witnessing the birth of the healthy divorce. In 2026, it is increasingly common to see former spouses attending their children's graduation or sporting events together, not out of a forced sense of duty, but because they didn't spend 3 years destroying each other's character in public records. The mediation process preserves the bridge between the past and the future. It treats the end of a marriage as a restructuring rather than a demolition. As we look at the broader historical trends, we see that the United States is moving away from the culture of litigation that defined the late 20th century. People are realizing that the legal system is a tool, not a therapist. But as the mediation model gains ground, a new set of questions arises. How does the industry ensure that the process remains fair for everyone involved? What happens when one party refuses to come to the table in good faith? And perhaps most importantly, How are the lawyers themselves adapting to a world where their traditional business model is being disrupted by peace? In the next part of this deep dive, we are going to look at the secret resistance to mediation, the hidden forces within the legal industrial complex that are fighting to keep the old stigma alive. We will explore the dark side of the billable hour, and how some firms are using fear as a marketing tool to discourage couples from seeking a peaceful resolution. You won't want to miss the breakdown of the predatory tactics used to keep families in conflict, and how you can spot them before you sign on the dotted line. While the rise of mediation represents a triumph of logic and emotional intelligence, it would be naive to ignore the significant institutional friction that still exists in 2026. To understand why some families still end up in the meat grinder of litigation, we have to follow the money. This is the part of the documentary where we pull back the curtain on the legal industrial complex. In the United States, the divorce industry is a multi-billion-dollar machine. Traditional law firm business models have historically been built on the billable hour. In this framework, conflict is not just a byproduct of the case. It is the primary revenue driver. When a case settles quickly through mediation, the law firm might see a few $1,000s in fees. When a case goes to a full-scale trial with depositions, expert witnesses, and endless motions, that same firm can generate hundreds of thousands of dollars. This creates a systemic disincentive for peace. Imagine a character named Michael in Seattle. It is early 2026 and Michael is terrified. His marriage is ending, and he is worried about his relationship with his daughter and the fate of the small business he spent 15 years building. He walks into a mahogany-paneled law office. The attorney he meets with doesn't start by talking about mediation or collaborative law. Instead, they lead with fear. They tell Michael that if he doesn't strike first, his spouse will take the business, the house, and primary custody. They use high-stakes language, painting a picture of a zero-sum war where the only way to protect himself is to authorize a scorched earth strategy. This is a classic example of a predatory intake process designed to bypass the client's rational mind and trigger their survival instincts. By the time Michael leaves that office, he is convinced that mediation is a trap for the naive. He has been successfully sold on a narrative where aggression equals protection. Historical trends in legal marketing show a heavy reliance on this warrior imagery. Even in 2026, you will see digital ads targeting recently separated individuals with slogans that emphasize fighting, winning, and crushing the opposition. This marketing directly feeds the dying stigma that mediation is for the weak. It frames the mediator as a passive bystander who will let a bully run over a peaceful partner. But the reality, supported by case studies of successful mediated settlements, is quite the opposite. A skilled mediator is a trained facilitator who identifies power imbalances and neutralizes them. In Michael's case, had he chosen mediation, the professional would have ensured that both he and his spouse had access to independent financial experts to value the business fairly, rather than spending $60,000 on two separate forensic accountants whose only job was to contradict each other in court. We need to look at the specific tactic known as the paper war. In a traditional litigated divorce, one party's attorney may file dozens of unnecessary motions or requests for production. Each of these requires a response from the other side, which generates more billable hours for both firms. It is a feedback loop of administrative costs. For a family in 2026, this is the equivalent of setting fire to their net worth. Mediation completely eliminates this phase. Because mediation is a voluntary, transparent process, the parties agree to an informal exchange of information. There are no surprise documents, no tactical withholding of bank statements, and no expensive process servers showing up at your workplace. The decline of the stigma is largely driven by people realizing that the paper war doesn't actually produce a better legal result. It just produces a smaller bank account. Another hidden force is the cultural ego within certain legal circles. For decades, the most respected divorce attorneys were the trial dogs, the ones who could dominate a courtroom and intimidate witnesses. In the old social hierarchy, being a mediator was seen as a secondary career for those who couldn't cut it in litigation. However, a massive shift has occurred by 2026. The most successful and sought-after professionals now are those who can navigate the complexities of human psychology and financial engineering to reach a deal. The status has shifted from the fighter to the fixer. We see this in the way law schools have revamped their curricula. In 2026, courses on alternative dispute resolution are no longer electives, they are core requirements. The legal community is slowly realizing that a lawyer's highest value is not in starting a fire, but in preventing one. Despite this progress, the predatory tactics persist in the form of the boutique litigation firm. These firms often target high-net-worth individuals by promising a boutique, customized war. They frame mediation as a generic, assembly line process that isn't sophisticated enough for the client's complex life. To counter this, let's look at a case study of a high-asset divorce in New York City in 2026. The couple had a combined net worth of over $50 million, including international real estate and private equity interests. Instead of a 3-year public trial, they engaged in a private, multidisciplinary mediation. They hired a mediator who brought in a neutral tax specialist and a neutral child psychologist. The process was highly sophisticated, entirely confidential, and cost a fraction of what a public trial would have. This case study is a direct refutation of the idea that mediation is only for simple cases. In fact, the more complex the assets, the more a family has to lose in a public adversarial setting. Step by step, the decline of the stigma is also being accelerated by the transparency of the internet. In 2026, law firms are subject to the same review culture as restaurants or hotels. When a firm drains a client's savings and delivers a mediocre result after 2 years of stress, that client leaves a digital trail. Prospective clients are doing their due diligence. They are looking for keywords like collaborative, resolution-focused, and efficient. The firms that rely on high-conflict models are finding it harder to attract informed clients. The market is effectively policing the industry. If you are an attorney in 2026 and you aren't offering mediation as a primary option, you are increasingly viewed as a dinosaur. However, we must address the psychological barrier of the anger phase. Divorce is rarely a mutual, calm decision. Usually, one person wants out more than the other, leading to feelings of betrayal, rejection, and a deep-seated desire for justice. The traditional court system sells the illusion of justice. It promises a day in court where a judge will tell your spouse they were wrong and you were right. This is almost always a lie. Most family court judges in the United States in 2026 will tell you that if both parties leave the courtroom feeling slightly unhappy, the judge did their job. They are there to divide property and time, not to validate your emotional pain. Mediation, ironically, offers more space for emotional closure because it allows for direct communication. It doesn't promise a legal victory, but it offers a potential outcome where both parties can move forward without the weight of a multi-year legal trauma. The resistance is real, but it is losing ground to the sheer weight of economic and social reality. The decline of the stigma is not just a trend. It is a fundamental restructuring of how Americans handle the end of a family unit. We are moving toward a future where the question is no longer who is your lawyer, but who is your mediator. By choosing to step away from the adversarial machine, families are reclaiming their power from a system that was never designed to heal them. But even with the best intentions and a qualified mediator, there is one variable that can still derail everything. It is the one thing no amount of money or legal expertise can fully control: the high-conflict personality. What happens when you are ready to mediate, but your spouse is committed to total destruction? In the next part, we are going to dive into the strategy of the defensive mediation. We will look at how to handle a narcissist or an obstructionist in the mediation room, the specific legal safeguards you need to have in place, and the exact moment you should walk away and head for the courtroom. This is the ultimate guide to protecting yourself when the other side refuses to play fair. To understand the tactical reality of mediation in 2026, we have to address the elephant in the room: the high-conflict personality. It is a common misconception that mediation only works for couples who are already friendly. In fact, the decline of the stigma is largely due to the realization that mediation is often more effective than litigation for managing difficult personalities. Imagine a character named Jennifer in Austin, Texas. Jennifer is ready to move forward, but her spouse, Mark, has historically used high-conflict tactics to exert control. In the old model, Jennifer would have been told that her only option was a protective litigation strategy that would cost her $40,000 and 3 years of her life. But in the modern landscape, Jennifer has access to a process known as defensive mediation. Defensive mediation is not about being soft. It is about utilizing professional structures to limit the opportunity for emotional abuse. The process begins with a careful screening by the mediator. In 2026, professional standards require mediators to conduct individual intake sessions. During these sessions, the mediator looks for red flags such as a history of intimidation, financial withholding, or a refusal to acknowledge shared facts. If Jennifer informs the mediator of Mark's tendency to derail conversations with personal attacks, the mediator adjusts the format. This might involve shuttle mediation, where Jennifer and Mark are in separate digital or physical rooms, and the mediator moves between them. This structural barrier removes the high-conflict partner's audience and their primary weapon, the ability to trigger an emotional response in their spouse. Case studies from 2025 and early 2026 show that when a high-conflict individual is removed from the high-stakes theater of a courtroom, their behavior often changes. In a courtroom, every outburst is a performance for the judge. In a mediation room, there is no judge to impress and no legal audience to manipulate. The mediator, acting as a neutral gatekeeper, can simply pause the session or set firm boundaries on communication. For Jennifer, this means she can negotiate the division of their community property without having to endure 4-hour depositions where Mark's attorney grills her on her personal life. The potential outcomes of this strategy are significant. Jennifer maintains her dignity, saves tens of thousands in legal fees, and reaches a legally binding agreement that includes specific, enforceable communication protocols for the future. However, a key part of the masterclass in 2026 is knowing when the mediation process has reached its limit. While the stigma of walking away from the table has declined, the importance of recognizing bad faith has increased. A high-conflict partner might use mediation as a stalling tactic or a way to perform discovery for free. Jennifer needs to watch for specific step-by-step indicators of bad faith. Is Mark refusing to provide a sworn financial statement? Is he consistently showing up late or unprepared? Is he agreeing to terms in the room and then having his attorney send a contradictory letter the next morning? In these scenarios, the professional recommendation is not to double down on mediation, but to utilize the progress made to pivot into a narrow-scope litigation. This is where you take the 80% of issues you did agree on and only ask a judge to decide the remaining 20%. This hybrid approach is a hallmark of the sophisticated 2026 divorce strategy. Let's look at the role of the consulting attorney within the mediation framework. A common myth that fueled the old stigma was that if you mediate, you don't get legal advice. That is categorically false in the modern U.S. system. Jennifer would have her own consulting attorney who stays in the background. This attorney reviews the mediated agreements before they are signed to ensure her legal rights are protected. This creates a two-tier safety net. The mediator facilitates the deal, and the consulting attorney verifies the deal. Historical trends show that this collaborative consultative model leads to much higher compliance rates than court-ordered settlements. People are far more likely to follow a plan they helped create than one a stranger in a black robe forced upon them. Data from the American Family Law Institute suggests that mediated agreements have a 70% lower rate of post-divorce litigation compared to court-issued orders. This is a staggering statistic. It means that by investing in mediation now, Jennifer is significantly reducing the likelihood that she will be back in court in 2028 or 2030. For the U.S. audience, this is the ultimate long-term financial and emotional insurance policy. When we talk about the decline of stigma, we are talking about the rise of long-term thinking. The old way was about winning today. The new way is about being free tomorrow. Imagine if every divorcing couple in the U.S. understood the financial engineering involved in a mediated settlement. In a courtroom, a judge usually follows a rigid formula for asset division. In mediation, Jennifer and Mark can engage in creative problem-solving that a judge simply does not have the authority to order. For example, they could agree to a deferred sale of the family home until the youngest child graduates high school, with a specific formula for sharing maintenance costs. They could trade retirement assets for liquid cash to help one partner start a new business. These bespoke solutions are why mediation is increasingly seen as the premium option for those with complex lives. Now, consider the impact of the 2026 economic environment on these decisions. With interest rates and housing market volatility being top of mind for many Americans, the ability to negotiate the nuances of a mortgage or a real estate portfolio is critical. A court-ordered sale of a house in a down market can be a financial disaster. Mediation allows the couple to consult with a neutral financial professional who can help them time the market or structure a buyout that makes sense for both parties. This level of granular control is impossible in the adversarial system, where the goal is simply to close the file. The shift we are documenting is also about the reclamation of the narrative. When you litigate, your life is summarized into a series of exhibits. Your character is reduced to a set of allegations. In mediation, you retain the right to speak as a human being. This has a profound effect on the potential for a functional co-parenting relationship. If Mark and Jennifer spend 2 years accusing each other of being unfit parents in public filings, how are they supposed to stand together at a soccer game the following year? The decline of the stigma is an acknowledgement that the social cost of litigation is often higher than the financial cost. To wrap up this segment of our deep dive, we have to look at the global context. The United States is currently leading a shift that is being watched by legal systems worldwide. By prioritizing resolution over retribution, we are fundamentally changing the DNA of family law. We have moved from a system that asks who is at fault to a system that asks what is the best path forward. This evolution is not just about divorce. It is about how we as a society handle conflict in its most intimate form. But as we master the art of the mediated exit, there is a technical hurdle that many families overlook until it is too late. It is the hidden complexity of the documents themselves. What happens after the mediator says you have a deal? How do you ensure that the memorandum of understanding actually becomes a rock-solid legal judgment that protects you 10 years from now? In the next part, we are going to break down the drafting phase, the most dangerous part of the mediation process. We will look at the exact clauses you need to include to prevent future loopholes and the one document that, if missing, could render your entire mediation useless in the eyes of the law. You will see how a single word in a settlement agreement can be the difference between a clean break and a decade of legal headaches. The transition from a successful mediation session to a legally enforceable judgment is the phase where most families mistakenly lower their guard. In 2026, the decline of the stigma surrounding mediation has led to a surge in couples reaching verbal agreements. But the real work lies in the translation of those conversations into a marital settlement agreement, or MSA. Imagine a character named Robert in Chicago. Robert and his spouse have just spent 3 days in mediation and have reached a consensus on everything from the division of his tech company stock options to the summer visitation schedule. They leave the mediator's office feeling a sense of immense relief. However, the document they carry out is often just a memorandum of understanding. This is a non-binding summary of their intent. For Robert, the danger zone begins now. If that memorandum is not meticulously converted into a formal legal judgment, the entire process could collapse, leading back to the very litigation they fought so hard to avoid. The technical depth of this drafting phase cannot be overstated. In the United States, family law is not just about intent, it is about precision. Historical trends show that ambiguous language in a divorce decree is the #1 cause of post-divorce litigation. Consider the phrase reasonable visitation. In the heat of a friendly mediation, that might sound flexible and cooperative. But 3 years later, in 2029, if Robert and his former spouse are no longer on speaking terms, reasonable becomes a subjective battleground. Does it mean every other weekend? Does it include Tuesday dinners? A professional mediator or a consulting attorney in 2026 will insist on a specific, granular schedule that acts as a default. Step by step, the drafting process must account for the what-ifs. What if one parent moves more than 50 miles away? What if the cost of health insurance premiums increases by more than 20%? By addressing these potential outcomes during the mediation drafting phase, Robert is effectively pre-solving conflicts that haven't even happened yet. Let's examine a case study involving the division of complex financial instruments like restricted stock units or 401k accounts. In a traditional courtroom setting, a judge might simply order these assets to be split 50-50. However, the tax implications of such a move can be devastating if not handled correctly. In 2026, a sophisticated mediated agreement will include a specific instrument known as a Qualified Domestic Relations Order, or QDRO. This is the document that actually instructs a plan administrator to move funds from one spouse's retirement account to the other's without triggering immediate taxes or early withdrawal penalties. If Robert's MSA mentions the split but his team fails to file the QDRO, he could find himself 5 years down the line with a massive tax bill and a legal headache that requires reopening the case. This level of detail is why the stigma of mediation being a simple handshake deal has vanished. It is now recognized as a high-level logistical operation. Furthermore, we must look at the concept of merger and survival in legal drafting. This is a technicality that can change the entire trajectory of a person's financial future. In many U.S. jurisdictions, certain parts of an agreement can be drafted so that they merge into the final court order, meaning they can be modified later if circumstances change, such as child support. Other parts can be drafted to survive as independent contracts, meaning they are much harder to change, providing a higher level of certainty for things like alimony or property division. Imagine if Robert agrees to a specific spousal support amount based on his current high-earning years. If the language is not clear about whether this amount is non-modifiable, He might find himself back in court in 2030 trying to argue for a reduction after a career change. The mastery of these legal nuances is what separates a viral success story from a cautionary tale. The role of the court in this final stage is also evolving. In 2026, many U.S. family courts have adopted an expedited track for mediated agreements. Because the parties have already done the heavy lifting of negotiation, the judge's role is primarily to ensure the agreement is not unconscionable and that the best interests of the children are met. However, the judge will not fix your typos or close your loopholes. They will sign what you put in front of them. This is why the contemporary American approach involves a final review by independent legal counsel. Even though the mediation was neutral, having a second pair of eyes that is looking out solely for your interests ensures that the single word that could cause a decade of headaches is caught before the ink is dry. Another critical element is the inclusion of a dispute resolution clause within the final agreement itself. Historical trends indicate that even the best-laid plans encounter friction. A forward-thinking MSA in 2026 will mandate that if a disagreement arises in the future, say, regarding which private school a child should attend, the parties must return to mediation before they are allowed to file a motion in court. This creates a self-correcting loop. It institutionalizes the peace. For Robert, this means that even if the relationship sours, the legal framework he built during his divorce provides a roadmap back to a neutral room rather than a battleground. Case studies of high-net-worth individuals in 2026 show that they are increasingly using these detailed agreements to handle digital assets, including cryptocurrency and intellectual property rights. A judge might not understand how to divide a cold storage wallet or the future royalties of a burgeoning YouTube channel. Mediation allows for the creation of specific clauses that dictate how these assets are valued, audited, and distributed over time. This flexibility is a primary driver in the decline of the litigation stigma. When the assets are modern, the legal tools must be modern as well. Step by step, the finalization process usually follows this path. The mediator drafts the memorandum of understanding, the parties review it with their respective attorneys, the formal marital settlement agreement is drafted, the QDROs are prepared for retirement assets, and finally, the package is submitted to the court for a judge's signature. In many cases, this can now be done entirely through electronic filing systems, meaning the parties never even have to set foot in a courthouse. This lack of physical confrontation further lowers the emotional temperature and solidifies the perception of divorce as a private, administrative transition rather than a public moral failure. But even with a perfect document, there is a lingering fear that haunts many Americans embarking on this journey. It is the fear of the unknown, the question of what happens if the economy shifts, if one person loses their job, or if a global event changes the value of their assets overnight. How do you build an agreement that is both rock-solid and flexible enough to survive a world that feels increasingly unstable? In the next part, we are going to explore the concept of the future-proof divorce. We will look at the specific escalation and de-escalation clauses being used in 2026 to account for inflation, market volatility, and changing career paths. You will learn how to build a legal structure that doesn't just work for today, but acts as a living document that can weather any storm. The era of the static, brittle divorce decree is over, and we are going to show you exactly what the new resilient model looks like. To build a resilient family structure in 2026, we have to look at the concept of the future-proof divorce decree. For decades, the standard American divorce was a snapshot in time. A judge would look at the bank balances, the income statements, and the children's ages on a specific Tuesday in 2005 and issue an order that was supposed to last forever. But the world doesn't work that way anymore. In an era of rapid technological disruption, fluctuating interest rates, and shifting career paths, a static document is a liability. The decline of the stigma in mediation is largely driven by the fact that mediation allows for the inclusion of adaptive clauses that traditional court orders simply lack the nuance to implement. Imagine a character named Marcus in Denver. Marcus works in renewable energy, a sector that is currently booming but subject to significant regulatory shifts. His spouse, Elena, is a freelance UX designer whose income varies based on the projects she secures. In a traditional litigated setting, a judge might set a fixed child support amount based on their 2026 tax returns. But what happens in 2028 if Marcus's company is sold, or if Elena's niche is automated by new software? Under the old model, they would have to file a motion to modify, hire lawyers again, and wait 6 months for a court date. In the modern mediated model, Marcus and Elena build an automatic adjustment trigger directly into their agreement. This is often referred to as an escalation or de-escalation clause, Step by step, the mediator helps them define what constitutes a material change in circumstances. Instead of going back to court, they agree that if either party's income fluctuates by more than 15%, they will exchange new tax documents and use a pre-agreed formula to adjust the support levels. This isn't just a convenience. It is a massive financial safeguard. Historical trends in family law suggest that the cost of modifying a divorce decree can often exceed the actual amount of support being disputed. By automating this process, Marcus and Elena are opting out of the conflict cycle entirely. Case studies from the last 2 years show that this resilience is particularly important when it comes to the housing market. In many parts of the United States in 2026, home equity is a family's largest asset, but high mortgage rates make selling or refinancing a daunting prospect. A courtroom might order an immediate sale to split the proceeds, potentially forcing the family into a high-rent situation. Mediation, however, allows for a bird nesting clause or a deferred sale agreement. In this scenario, the children stay in the family home while the parents rotate in and out, or the sale is postponed for a set number of years until a specific interest rate target is met or a child completes a school milestone. This level of economic engineering is why mediation is no longer seen as the secondary option. It is the superior strategic choice for families who want to protect their net worth. Let's expand on the concept of the cost of living adjustment, or COLA. In 2026, the American public is hyper-aware of inflation. $1,000 in monthly support today does not buy the same amount of groceries or gas as it will in 2030. Mediated agreements are increasingly including clauses that tie support payments to the Consumer Price Index. While this sounds like a minor technicality, it prevents the slow erosion of the recipient's standard of living and removes the need for a future legal battle to correct for inflation. This proactive approach is a hallmark of the new, resilient model that is replacing the brittle decrees of the past. We also have to consider the future of education. Imagine if Marcus and Elena have a toddler in 2026. A traditional court order might say they will share college expenses, but that is notoriously difficult to enforce 15 years later, when costs have tripled. A future-proofed mediated agreement will specify the funding mechanism now. It might involve a 529 plan with specific monthly contributions and a tie-breaking mechanism for choosing between public and private institutions. By addressing these details while the parties are in the spirit of compromise, they are preventing a massive blowout in the year 2040. The deep dive into resilience also requires looking at the changing nature of work. In 2026, the gig economy and remote work have made the old 9-to-5 custody schedules obsolete. A resilient mediated agreement doesn't just list weekends. It creates a flexible framework for parenting time that can adapt to changing work travel or project deadlines. We are seeing the rise of the right of first refusal clause, which states that if one parent is called away for work for more than 4 hours, they must offer the other parent the opportunity to watch the children before calling a babysitter. This fosters a culture of cooperation rather than a culture of monitoring. Data from recent sociological studies indicates that when parents have a living document that they can adjust without legal intervention, their overall stress levels are lower, and their children report higher levels of stability. This is the ultimate goal of the modern U.S. divorce. The stigma of mediation used to be that it wasn't official enough. In 2026, the reality is that it is often more official and more legally robust because it accounts for the complexities of real life. However, even the most future-proofed agreement is only as good as its implementation. This brings us to the rise of the parenting coordinator and the private case manager. For high-asset or high-complexity families, the mediation process doesn't end when the papers are signed. They build a clause that appoints a neutral third party to act as an on-call referee for the next several years. If Marcus and Elena can't agree on which summer camp the kids should attend, they don't call lawyers. They call their coordinator, who has the authority to make a binding decision within 24 hours. This keeps the family out of the public record and out of the adversarial system indefinitely. We must also look at the role of insurance in these resilient structures. A sophisticated 2026 agreement will include specific life and disability insurance requirements to secure support payments. If the paying parent becomes unable to work, the agreement doesn't just fail. The insurance policy kicks in to provide for the children. This is the level of detail that the old static court orders rarely touched. By thinking through these contingencies, families are building a fortress around their post-divorce life. As we conclude this part of the deep dive, it is clear that the decline of the stigma is not just about being nice, it is about being smart. The American family in 2026 is navigating a world of unprecedented change, and they need a legal structure that is as dynamic as their lives. We have moved from the era of the final judgment to the era of the sustainable resolution. But there is still one major hurdle that keeps many people from pulling the trigger on mediation. It is the fear of being outmaneuvered. People worry that while they are being cooperative, their spouse is hiding assets in the shadows. How do you ensure total financial transparency in a process that happens behind closed doors? In the next part, we are going to explore the high-tech world of forensic mediation. We will look at the digital tools being used in 2026 to track down hidden accounts, value intangible assets like brand influence, and ensure that when you sit down at the mediation table, you are doing so with every single fact on the screen in front of you. You will see why the most advanced financial investigations are now happening inside the mediation room, not the courtroom. The fear of financial betrayal is often the final hurdle that keeps an American couple from walking through the doors of a mediation suite. For decades, the litigation model was sold on the idea that you needed a shark of an attorney to perform a formal discovery process to hunt down every penny. The old stigma suggested that mediation was only for people who trusted each other implicitly. But in 2026, the digital landscape has fundamentally changed the rules of transparency. We are now in the era of forensic mediation, where sophisticated technology and neutral financial experts provide a level of oversight that is often superior to the chaotic, adversarial filings of a courtroom. Imagine a character named Thomas in Charlotte, North Carolina. Thomas is a successful executive, and his spouse, Sarah, has been a stay-at-home parent for 10 years. Sarah is deeply concerned. She knows Thomas handled all the investments, and she fears that if they choose mediation, she will be agreeing to a settlement based on an incomplete picture of their wealth. In the old world, Sarah would have hired a lawyer to file subpoenas for bank records, a process that could take 6 months and cost $15,000 in legal fees alone. In 2026, Thomas and Sarah opt for a high-tech forensic mediation. The process begins with the appointment of a joint financial neutral. This isn't just an accountant. It is a professional trained to bridge the gap between financial complexity and emotional anxiety. Step by step, the neutral expert utilizes specialized software that connects directly to financial institutions via secure APIs. Instead of waiting for Thomas to manually print and mail bank statements, which could be redacted or altered, the software pulls real-time data from every brokerage account, mortgage lender, and credit card provider linked to their social security numbers. This creates an immutable digital ledger of the family's entire financial history. This level of transparency is the ultimate antidote to the trust gap. When the data is pulled directly from the source and displayed on a shared screen in the mediation room, the room for deception evaporates. Historical trends show that the most contentious assets in 2026 aren't just real estate and 401ks, but intangible and digital assets. We are seeing a massive rise in the need to value things like creator economy brands, crypto portfolios, and even high-value digital collectibles. Imagine if Thomas had been quietly investing in decentralized finance protocols or held a significant stake in a private startup. In a traditional court setting, a judge might not even know what questions to ask about a cold storage wallet or a rolling seed round investment. In forensic mediation, the neutral expert is often a specialist in digital forensic accounting. They can track blockchain transactions and use market-standard valuation models to put a fair price on a YouTube channel's future revenue or a startup's equity. Sarah isn't relying on Thomas's word. She is relying on a professional audit that both parties have agreed to fund jointly. Consider the case study of a tech-heavy divorce in Silicon Valley in early 2026. The couple had a significant portion of their net worth tied up in unvested stock options and various tiers of carry in a venture capital firm. A courtroom trial would have involved 2 different expert witnesses shouting conflicting numbers at a judge who may have limited experience with complex derivative units. Instead, they utilized a mediation process that brought in a neutral valuation firm. The expert ran Monte Carlo simulations to show the potential outcomes of the stock's performance over the next 5 years. This allowed the couple to negotiate a settlement based on a range of possibilities, including a clawback provision if the company went public at a certain valuation. This level of sophisticated financial engineering is why the stigma of mediation being simple is dead. It is now the preferred venue for the most complex financial lives in America. Another critical component of forensic mediation is the lifestyle analysis. This is where the neutral expert compares reported income against actual spending habits over a 3-year period. If Thomas claims he only makes $200,000 a year, but the digital ledger shows $500,000 in annual expenditures. The software flags the discrepancy immediately. This is far more efficient than the old method of deposition, where an attorney would spend hours asking, "Where did this $5,000 check go?" The technology does the heavy lifting, allowing the human beings in the room to focus on the solution rather than the investigation. Furthermore, we must address the issue of tax optimization. In 2026, the tax code is more complex than ever, and a poorly structured settlement can lead to an accidental loss of 20 to 30% of the total marital pot to the IRS. In the adversarial system, lawyers are often focused on the gross number, who gets the bigger piece of the pie. In mediation, the focus is on the net number. By working with a neutral tax professional, Thomas and Sarah can structure their asset split to minimize capital gains and maximize the tax-advantaged status of their retirement transfers. For example, they might decide that it is better for Sarah to take the liquid brokerage account, while Thomas keeps the primary residence, based on their individual future tax brackets. This is a win-win scenario that is almost never achieved in a courtroom battle, where the judge simply doesn't have the time or mandate to perform tax planning for the litigants. The decline of the stigma is also fueled by the use of sworn financial affidavits within the mediation process. Many people mistakenly believe that because mediation is private, there is no penalty for lying. In reality, in 2026, most professional mediation agreements in the U.S. require both parties to sign their financial disclosures under penalty of perjury. If Sarah discovers 2 years later that Thomas hid a secret offshore account, the mediation agreement often contains a specialized penalty clause. These clauses can stipulate that if an undisclosed asset is found, the hiding party must forfeit 100% of that asset to the other spouse. This creates a massive financial disincentive for dishonesty. Step by step, the mediation process moves from data aggregation to analysis and finally to the creation of what-if scenarios. Imagine the shared screen showing a dashboard of their lives. The mediator can click a button to show, if we sell the house and divide the proceeds this way, Sarah has X dollars for her next down payment, and Thomas has Y dollars for his retirement. If we keep the house and Thomas pays Sarah a lump sum from his 401k, the numbers change to this. This visual, data-driven approach removes the emotional fog of war. It turns a divorce from a moral judgment into a logistical puzzle. The impact of this transparency on the American public is profound. It allows for a sense of procedural justice. Even if the end of the marriage is painful, the parties feel that the process was fair because they had access to all the information. This is why the stigma is declining. People are realizing that you don't need to be an enemy to be honest. You just need the right tools. But even with total financial clarity and a perfect legal document, there is one area where mediation is currently facing its toughest challenge. It is the realm of the deep-seated, generational trauma that often bubbles to the surface during a divorce. What happens when the numbers make sense but the hearts are still at war? How do you handle the emotional gridlock that can stall even the most high-tech mediation? In the next part, we are going to dive into the world of therapeutic mediation. We will look at how 2020 SXS top professionals are integrating trauma-informed care into the legal process, the specific techniques used to break through years of resentment, and why the future of the American family depends on our ability to heal as we part ways. You will see how the most successful mediators are now part lawyer, part psychologist, and part diplomat. The integration of trauma-informed care into the legal landscape of 2026 marks the most humanistic turn in the history of American family law. To understand why the stigma of mediation has declined so sharply, we must look beyond the balance sheets and examine the psychological architecture of the process. In previous decades, the emotional fallout of a divorce was considered a side effect to be managed by therapists, while the lawyers handled the business. This siloed approach was a primary driver of high-conflict litigation, as the unaddressed pain of the parties often expressed itself as petty disputes over property. But today, the most effective mediation practices in the United States operate on the principle that if you do not resolve the emotional gridlock, the legal resolution will remain out of reach. Imagine a character named Emily in Boston. Emily is navigating a divorce in 2026 after a 15-year marriage that ended due to a deep breach of trust. On paper, her financial split is straightforward. However, every time her spouse, David, speaks during their sessions, Emily physically freezes. Her heart rate climbs, and her ability to process logical financial data shuts down. In a traditional courtroom, a judge would see Emily's hesitation as obstructionism or indecision. Her own litigator might push her to make a snap judgment to keep the billable hours from climbing. But in a therapeutic mediation model, the professional recognizes this as a nervous system response. Step by step, the 2026 mediator utilizes techniques drawn from somatic experiencing and neurobiology to de-escalate the room. This might involve something as simple as changing the seating arrangement or moving to a virtual platform where Emily feels more secure in her physical environment. It also involves the use of caucus sessions, where the mediator spends time individually with each party not just to talk about numbers, but to identify the underlying fears driving the conflict. For Emily, the fear isn't just about the house. It is a fear of future instability caused by the betrayal. Once the mediator acknowledges this and helps David understand how his communication style is triggering that fear, the gridlock begins to loosen. This is the diplomat role in action, translating emotional needs into negotiable terms. Case studies from the American Family Mediation Association show that when trauma-informed techniques are applied, the time to reach an agreement is reduced by nearly 40%. This happens because the parties stop using the legal process as a proxy for their emotional pain. In the US today, we are seeing a historical trend where mediation suites are being designed with these psychological needs in mind. Gone are the fluorescent lights and cold conference tables. They are replaced by environments that promote calm, neutral colors, natural light, and private breakout rooms. This isn't fluff. It is a strategic design intended to keep the brain in a state where it can perform the complex task of restructuring a family. Consider the role of the divorce coach, a profession that has exploded in popularity across the United States in 2026. A divorce coach is not a therapist and not a lawyer. They are a behavioral specialist who helps a client manage the logistics of the transition while keeping their emotions in check. Emily might hire a coach to help her prepare for her mediation sessions, practicing how to stay grounded when difficult topics arise. This preparation allows the mediation itself to remain a high-efficiency environment. The decline of the stigma is deeply tied to this professionalization of emotional management. It is no longer seen as a sign of weakness to have a support team. It is seen as the most efficient way to ensure a high-quality potential outcome. Furthermore, we must address the concept of the apology in mediation. In a litigated divorce, an apology is often viewed as an admission of guilt that could be used against you in court. Lawyers will actively advise their clients to remain silent and stoic. In mediation, however, a sincere acknowledgement of pain can be the single most powerful tool for reaching a settlement. In 2026, mediators are trained to facilitate these moments of emotional accountability. When David is able to look at Emily and acknowledge the impact of his actions without the fear of legal repercussions, the need for Emily to seek justice through a punitive financial settlement often evaporates. The mediation room provides a safe harbor for the truth, which the public courtroom fundamentally cannot. Data from 2025 psychological surveys of divorced Americans indicates that individuals who participated in therapeutic mediation reported a 60% higher satisfaction rate with their post-divorce relationship with their former spouse. This is critical for the millions of American families with children. When the parents heal during the process, the children are spared the secondary trauma of a lifelong Cold War. We are moving away from the era of the broken home and toward the era of the restructured family. This shift is supported by the rise of co-parenting apps and digital tools that are introduced during the mediation process to help parents transition from lovers to business partners in the enterprise of raising their children. Step by step, the mediator helps the couple draft a communication covenant. This is a document that goes beyond the legal custody schedule to define how they will speak to each other, how they will handle new partners, and how they will share information about the children's health and education. By putting these expectations in writing, they are creating a behavioral roadmap that prevents future friction. Imagine if Emily and David had a pre-agreed plan for how to handle a disagreement over a holiday schedule that didn't involve calling their lawyers. This level of foresight is only possible when the emotional foundation has been addressed. But let's look at the broader social implications. In 2026, the US is experiencing a loneliness epidemic and a mental health crisis. The old-school adversarial divorce only served to exacerbate these issues, leaving individuals financially drained and emotionally shattered. The decline of the stigma in mediation is a direct response to a society that is hungry for more sustainable ways to handle human conflict. We are seeing businesses, religious organizations, and community centers across the country starting to offer mediation-based conflict resolution training as a life skill. The divorce mediation room is simply the most high-stakes version of this new cultural value. The success of the therapeutic model also relies on the mediator's ability to remain truly neutral, while still being empathetic. This is the diplomat's greatest challenge. They must hold space for Emily's trauma while ensuring that David does not feel vilified or ganged up on. In 2026, many mediators are utilizing peer supervision groups where they discuss their cases with other professionals to ensure they are maintaining this delicate balance. This commitment to professional excellence has helped build the public trust that was missing 20 years ago. As we reach the conclusion of this deep dive into the heart of mediation, it becomes clear that the legal document is only the skeleton of a divorce. The emotional resolution is the flesh and blood. Without both, the structure cannot stand. We have seen how technology provides the facts and how psychology provides the path. But there is one final piece of the puzzle that remains invisible to most people until the very end. It is the role of the community, the friends, family, and social circles that surround a divorcing couple. How does the decline of the stigma in the courtroom translate to the Thanksgiving table? What happens when the legal battle is over, but the social judgment remains? In the next part, we are going to explore the social architecture of divorce in 2026. We will look at how the shift toward mediation is changing the way we support our friends through a split, the rise of the divorce shower and positive transition ceremonies, and how you can protect your social capital during a transition. You will see how the American community is finally catching up to the wisdom of the mediation room. The shift toward mediation has not only transformed the legal and financial landscapes, but has also triggered a massive reorganization of the American social fabric. In 2026, the way a community reacts to a divorce is fundamentally different from the judgmental whispers of the past. For decades, the social stigma was rooted in the concept of a failed marriage, which necessitated taking sides. If there was a legal battle, friends and family felt compelled to join a camp, acting as secondary combatants in a proxy war. But as mediation has become the dominant historical trend, the social response has pivoted from choosing sides to supporting the transition. This is the rise of social capital preservation. Imagine a character named Chloe in Atlanta. In 2026, Chloe and her spouse decide to end their marriage through a collaborative mediation process. In 1996, Chloe might have expected to lose half of her social circle as friends felt awkward or pressured to choose between her and her husband. In 2026, Chloe's social circle utilizes a different script. Because Chloe and her husband communicated their decision as a joint, mediated resolution, they effectively gave their community permission to remain neutral. This is a crucial step-by-step evolution in social dynamics. By presenting a united, non-adversarial front, the couple prevents the fracturing of their support network. Chloe isn't just saving money on lawyers. She is saving her relationships with her in-laws, her neighbors, and her lifelong friends. Case studies in 2026 show the emergence of the divorce announcement as a tool for stigma reduction. Instead of a scandalous secret that leaks out through the grapevine, many American couples are now using carefully crafted, neutral social media statements or emails to their inner circle. These announcements often explicitly mention that the couple is working through a professional mediation process to prioritize the well-being of their family. This proactive transparency changes the potential outcomes of the social transition. It frames the divorce not as a catastrophe, but as a managed change. We are even seeing the rise of the divorce registry or the transition shower. While this might have seemed radical a decade ago, in 2026, it is viewed as a practical way for a community to help two people set up separate households without the crushing financial burden that usually accompanies a split. Consider the role of the American workplace in this social shift. In the past, going through a divorce was often a career killer, or at least a significant professional setback, due to the time required for court appearances and the emotional instability of litigation. In 2026, many major U.S. corporations have integrated mediation support into their employee assistance programs. They recognize that a mediated divorce means fewer missed workdays and a more focused employee. Imagine Chloe's boss in Atlanta. Instead of seeing Chloe as a liability who will be tied up in depositions, the company sees her as an executive managing a complex life transition with maturity. This professional acceptance is a massive pillar in the decline of the stigma. When your employer treats your divorce as a logistical matter rather than a moral failing, the social shame evaporates. Historical trends also point toward a radical change in how we handle holiday traditions and shared social spaces. In the old litigation model, the Thanksgiving table was a site of trauma and exclusion. In 2026, we see the rise of the blended holiday. Because mediation fosters a culture of compromise rather than retribution, it is increasingly common for mediated families to share a meal, or at least coordinate their celebrations without the presence of a process server. This isn't just about being polite. It is about the preservation of social capital for the next generation. Children who see their parents navigating a social space with dignity are significantly less likely to experience the long-term psychological scars associated with high-conflict splits. The data from 2025 sociological surveys suggest that social isolation after divorce has decreased by 35% since the widespread adoption of mediation. This is because mediation encourages the parties to stay in the same social ecosystem. If you didn't spend 3 years accusing your spouse of being a monster in a public record, you can still show up to the same neighborhood barbecue or school fundraiser. The social cost of litigation was always hidden, but in 2026, Americans are finally putting a price tag on it. They are realizing that the ability to remain a respected member of your community is worth more than a few extra percentage points in an asset split. Step by step, the American community is also developing new rituals to replace the old stigmas. We are seeing the growth of positive transition ceremonies, small gatherings where friends acknowledge the end of a chapter and the beginning of a new one. These events are not celebrations of the divorce itself, but celebrations of the courage it takes to choose a peaceful path. For Chloe, this might look like a weekend away with her closest friends where they focus on her future goals and her new identity as a co-parent. By ritualizing the change, the community validates the mediation process and reinforces the idea that there is no shame in a respectful ending. We must also look at the impact on extended family. In the adversarial model, grandparents were often the silent victims, losing access to their grandchildren as collateral damage in the legal war. Mediation specifically addresses these extended family dynamics. A well-crafted 2026 mediation agreement often includes a section on grandparent visitation and the involvement of extended family in the children's lives. This ensures that the social fabric of the entire family tree remains intact. Case studies from the Midwest show that families who utilize mediation report significantly higher levels of contact with paternal and maternal relatives post-divorce than those who litigate. Furthermore, the rise of the conscious uncoupling movement, which started as a celebrity trend, has been democratized. In 2026, the average U.S. citizen understands that a relationship's success is not strictly defined by its duration. This philosophical shift has been a huge driver in removing the stigma. If a marriage served its purpose for a decade and then ended peacefully, the community no longer views it as a failure. They view it as a completion. This change in language is subtle but powerful. We have moved from the language of breaking to the language of evolving. But as we embrace this new social reality, we must also recognize the risks of the digital age. In a world where every detail of our lives can be documented and shared, how do we protect the privacy that mediation promises? How do we ensure that the social peace we have worked so hard to build in the mediation room isn't destroyed by a single impulsive post on a social network? In 2026, the intersection of privacy law and family mediation is the new frontier. As we move into the final part of this documentary, we are going to look at the ultimate conclusion of the mediation revolution. We will explore the long-term historical impact on the American legal system and what the next 10 years might hold. We will dive into the concept of the finality of peace, how to ensure that once you have mediated your divorce, it stays mediated. We will look at the final checks and balances you need to perform to ensure your legacy is protected and your future is truly your own. You will see how the decline of the stigma is not just a change in how we divorce, but a change in how we live. The final part of the masterclass is about to begin. The arrival of 2026 marks more than just a chronological milestone. It signifies a complete paradigm shift in the American philosophy of conflict resolution. We have moved from a culture that viewed the end of a marriage as a failure to be litigated, to one that views it as a complex transition to be managed with precision and empathy. To conclude this deep dive, we must examine the final layer of the mediation revolution, the long-term legacy of the finality of peace. In the United States, the ultimate metric of a successful divorce is no longer who won the house, but how many years the family stays out of the courtroom after the papers are filed. Imagine a character named Benjamin in Phoenix, Arizona. It is the year 2026, and Benjamin has just completed his final mediation session. He holds a digital copy of his decree, but more importantly, he holds a roadmap for his future. In the old world of 1996 or even 2016, Benjamin would likely have felt a sense of lingering resentment, a feeling that something was left unfinished or that he had been outmaneuvered. This resentment is what fuels the multi-decade legal battles that haunt so many American families. But because Benjamin participated in a high-transparency, forensic, and therapeutic mediation, his psychological closure is as robust as his legal one. This is the finality of peace. It is the ability to walk away knowing that every stone was turned and every voice was heard. Step by step, the finality of peace is achieved through a process known as the post-mediation audit. In 2026, top-tier mediators do not just send you on your way once the judge signs the decree. They schedule a follow-up session 6 months later. During this session, Benjamin and his former spouse meet to review how the agreement is working in the real world. Are the transfer of funds happening on time? Is the parenting schedule actually functional given their current work lives? This audit acts as a pressure relief valve. Instead of letting small frustrations build into a new legal filing, the parties address them in a neutral room. This historical trend of ongoing support is the final nail in the coffin of the litigation stigma. We are realizing that a family is a living organism, and a divorce decree should be a living, breathing document, not a static cage. Historical trends in U.S. family law indicate that the next 10 years will see an even deeper integration of AI and predictive analytics into the mediation process. We are already seeing prototypes of software that can analyze thousands of case studies to suggest potential outcomes for child support and alimony based on real-time economic shifts. For someone like Benjamin, this means that his future adjustments won't be based on a guess, but on data-driven models that both parties trust. This technological transparency removes the ego from the equation. When a computer model shows that a change in support is the most logical path for the family's total financial health, the adversarial impulse is neutralized. Furthermore, we must look at the concept of the legacy transition. In 2026, mediation is being used not just for the dissolution of the marriage, but for the preservation of the family's multi-generational wealth and values. Benjamin and his former spouse might include a clause that outlines their shared commitment to their children's inheritance, ensuring that the divorce doesn't lead to a fractured legacy. They might set up a joint charitable foundation or a family trust that they continue to manage together as co-trustees. This level of cooperation was almost unthinkable under the old litigation model, where the goal was to separate as completely and destructively as possible. Mediation allows for a functional, professional partnership to emerge from the ashes of a romantic one. The data from the last 5 years is clear. Mediated families in the U.S. report higher rates of financial recovery and lower rates of chronic health issues compared to those who litigate. The stress of the courtroom is a literal toxin, and by choosing mediation, Americans are choosing longevity. Case studies of individuals who have reached the 5-year post-mediation mark show a remarkable level of social reintegration. They are not defined by their divorce. They are defined by their ability to navigate change with grace. This is the ultimate goal of the deep dive. We are talking about the reclamation of the American spirit from a system that was designed to divide us. Consider the role of the next generation. The children of 2026, who are witnessing their parents mediate their differences, are learning a new language of conflict. They are seeing that it is possible to disagree profoundly and still treat the other person with respect. This is perhaps the most significant potential outcome of the decline of the stigma. We are raising a generation of Americans who will view the courtroom as a last resort, not a first response. They will be the mediators of the future, applying these principles to business, politics, and community leadership. The revolution that started in the divorce room is spreading to the boardroom and the town hall. As we look toward 2030, we see a landscape where the adversarial divorce is the exception, not the rule. We see a legal system that has been hollowed out of its predatory billing practices and replaced by a resolution-focused service industry. We see a society that no longer whispers about the neighbors who got divorced, but instead admires the neighbors who navigated their transition with transparency and logic. This is the world that mediation has built. But before we close this chapter, there is one final reality check. Mediation is not a magic wand. It requires two people to show up, even when they are hurting, and engage in the hard work of self-governance. It requires a commitment to the truth and a willingness to look past the immediate pain toward a long-term goal. For Benjamin, the journey wasn't easy. There were days of frustration, moments of fear, and long hours of looking at spreadsheets. But as he stands in 2026, looking at his children and his stable financial future, he knows it was the only path worth taking. The decline of the stigma of divorce mediation is the story of America growing up. It is the story of a people realizing that we don't need a judge to tell us how to be a family. We just need the right tools, the right experts, and the courage to stay at the table. The masterclass on mediation is now complete, But your journey is just beginning. As you move forward, remember that the finality of peace is not something you find. It is something you build, one conversation at a time. However, as the dust settles on the old system, a new question is emerging on the horizon. As we master the art of the peaceful exit, how will this change the way we enter into relationships in the first place? We are already seeing the rise of the mediated prenuptial agreement, a proactive, deep-dive conversation that happens before the wedding. In the next part of this series, we will explore the world of the marriage contract 2.0. We will look at how 2020 SIX's most successful couples are using mediation tools to build stronger, more transparent marriages from day one, and why the most romantic thing you can do for your partner might be to sit down with a mediator before you say I do. You won't want to miss the breakdown of how we are finally future-proofing the American marriage.